I'm going to go ahead and call this evening's meeting of the Clayton City Council to order for July 17th. Please let's show that the council members are present with the exception of Vice Mayor Shuey. And ask the audience to join us to the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, next up is the consent calendar.
Move approval.
Second.
Been moved and seconded that the consent calendar be approved as submitted. All in favor?
Aye.
No one opposed? All right. Next would be recognitions and presentations, but this evening we don't have any, so we'll move to the next item, which is reports. And first would be Planning Commission, Commissioner A.J. Shapiro.
Hello, Council. On Tuesday, June 26th, the Planning Commission voted unanimously in favor that the city's capital improvement program projects for the fiscal year of 2018 to 2019 are in conformity with the Clayton General Plan and that there is no possibility this finding may have significant effect on the environment. So there were 9 projects in there. And that's it.
Okay.
That's all.
That's it?
That's all.
All right. Any questions? No? All right. Thanks, A.J. Next up would be Trails and Landscape, but they didn't hold a meeting since our last meeting. So next would be City Manager. Gary?
No report tonight, Mr. Mayor. Thank you.
All right. Moving on to City Council then. Councilman Catalano.
I think the only items I have to report, which are therefore the same as everybody else, I attended the very lovely 4th of July parade that we had in our city, and then I was also had an opportunity to stop by the barbecue cook-off, but that's it. Oh. I'll repeat that then. Are our mics on? I think they're on, yeah. Attended the 4th of July parade and also the barbecue cook-off. That's it.
Councilmember Pierce.
Yeah, it's been a month since we've met, so there were quite a few meetings in the intervening time. We had the annual Metropolitan Transportation Commission and Association of Bay Area Governments Legislative Forum in Sacramento, where we had the pleasure of hearing from about 8 of our local elected officials in Sacramento, telling us what they're working on this year and letting us give them feedback. So that was a good collaborative process, and we're hoping they will listen. Also had a Contra Costa Transportation Authority meeting that same evening and went to the 2018 installation dinner of the what used to be called the Contra Costa Council. It's now the East Bay Leadership Group. Very responsible for doing an awful lot in the community. We had a concert in the Grove. Pride and Joy is one of our best concerts and brought in probably our best donations to date. So that was good. Also had 6 meetings of the Metropolitan Transportation Commission and had a fabulous 4th of July parade and served on jury duty for a couple of days and back to normal schedule. So that's it.
All right. Even though it's summer, you were busy as usual. Councilmember Diaz.
Yes, I had a few meetings. The first we had was our second car show last June 27th. Had a CBCA meeting on the 28th. 4th of July parade and festivities on July 4th on Wednesday. And then this last Saturday participated in the 9th annual Clayton barbecue. That's it.
Okay. And then since our last meeting here in the council, I did have a County Connection meeting on June 21st. We went over more information on new routes that are being proposed. On June 25th, have a Habitat Conservancy meeting where we reviewed the activity and budget updates for all of their activities. On the 28th, also attended the CBCA monthly member meeting. On the 30th of June, officiated and gave the awards for the Bocce League spring season and the summer season has started now, started on Sunday. July 4th, also attended the 4th of July parade. Looked like one of the bigger crowds that we've had in the years, and luckily the weather cooperated, so that was a nice parade. Then on the 10th of July, attended the Clayton Barbecue Committee meeting in preparation for the barbecue cook-off. On the 11th, attended the County Connection and looked at the administrative and finance subcommittee updates and budget information. On the 20th, attended the Mayor's Conference in Pittsburgh, where we had a presentation on the state of medical services, both from a hospital perspective and private practice, which is really a group of physicians, which is the typical approach now most private physicians are taking. And the medical environment continues to evolve. So that was very interesting. And then on the 14th, also worked at the Clayton Barbecue Cook-Off. And it was our biggest barbecue cook-off, attended by, reportedly up to 10,000 people. So I know Main Street was certainly full for a while in the afternoon. And again, the weather cooperated and we had music that evening. So a nice event. All right. Moving on to public comment. And this is the item on the agenda where members of the audience can address the council on items that are not on tonight's agenda. So I only have one speaker card for this item. Glenn Miller. Glenn?
Yes, thank you, Mayor and City Council and staff and members of the public. I'm here tonight to talk about an issue and essentially make a request. Just to give you a little bit of background, my neighbors have been complaining to me that I must know something that I could tell them about the infrequency of the fountain use. And so I have reached out to Keith Hayden to get some explanation of what the policy is. It did come to fruition with an unfortunate circumstance where one of my neighbors had a visitor from Afghanistan. He's going to be serving his third tour, and he came for the Memorial Day weekend, and the fountain wasn't on. I understand that was a lack of communication issue, but it really brought to the fore my neighbor's complaints. I live in Peacock Creek. We really see infrequent use of the fountain, and we pay for it. And so, what's the deal? So I did talk to Keith about it a little bit, and he gave me a basic broad brush of the policy. So, and he said it was certain days, certain city events, and what I could not understand is why we don't honor and recognize federal holidays, all of the federal holidays. So that is one of the things that I wanted to bring up. I would like you to just reconsider the policy. I was hoping Mayor Shuey's, because I was going to share this campaign slogan for the two of you, since you're going to be up for re-election, that you found us some more days for the fountain, and that would be the end of it. But if that's not acceptable after your deliberation, then I'd like to have this as a formal council meeting agenda item. And as part of that, I'd like to see a report that would at least touch base and include some of the basic operational agreements, like the development agreements, the applicable development agreements during the construction and development of Oakhurst, and some of the current assessments that we have been paying and continue to pay, which I know will cover those things. The other thing I'd like to see is what would be the cost. Now, I could do that for you. I know some professionals. You give me the cut sheets on the pumps, and I will let you know what the electrical costs for about 24 hours of service, since the stuff is there. And I also would like to know what special events are paid for, or the fountain's on, but nobody pays for them. So I know that Art and Wine, and then somebody might be paying for them. I don't know. Keith was not able to give me that information. I know Art and Wine, something like Mayor's Conference. So you have my information. That's my request.
Well, before you leave, not knowing if you were going to come this evening, I did go ahead and ask the city manager to at least look up and be able to share the city policy, the current policy on the use of the fountain. Gary?
Thank you, Mr. Mayor. As Mr. Miller knows, this was an item of discussion when I think it started with the Blue Ribbon Committee on the Landscape District and evolved into the Citizens Committee. But there were frequently discussions about we should operate the Clayton fountain every day. And as that committee, working with staff, got into the dialogue, the committee felt that the cost, to have that in the landscape district, because the land in that area is also part of the citywide landscape district, the cost was prohibitive in terms of other uses that money needed to be used for, such as taking care of the landscaping, taking care of irrigation, and so forth. However, this is not a secret, and Mr. Miller is happy to, I'll give him this copy. The original operational policy was approved by the City Council in April of 2002. That was in a public setting. It was when a question was asked about, well, why not on certain dates? The City Council revisited the item on July 16th of 2002, and the Council confirmed the dates that are listed here. And then it was amended in February of 2008, and I think at that time, the Clayton Garden Club tour weekend was added at that particular time. The dates that it operates, no one is paying for them except the taxpayers. It comes out of the landscape district budget. However, included in the operational policy is the opportunity for private parties or other organizations or entities, if they wish to have the fountain running. And this has occurred over periods of time. Let's say there's a wedding that's occurring at Oakhurst and the couple decides they want the fountain on for wedding pictures. They have actually come in to pay the operational cost for that particular weekend. I think that part of the question is although it wasn't said directly in terms of recognizing federal holidays, is because some of those federal holidays are religious holidays, and there is in fact separation of church and state. I recognize those holidays as well. People, you may not like that answer, but in order to allow, let's say, the fountain to operate on a religious holiday, it would then be necessary to allow the operation of any holiday recognized by religious groups. So that's the framework for this. And Mr. Miller, here you go. Here's the copy of that policy for you.
So I then reiterate my request to have this as an agenda item.
Okay.
Because I do not think that a blue ribbon panel or whatever gets to the crux of the matter. This is not a landscape maintenance district resource. This was an Oakhurst development resource. We are paying our taxes. We continue to pay assessments. So a decision made by a landscape maintenance blue ribbon committee on priorities, I think was a wrong approach. But I could be wrong, but I think that deserves some debate. And as far as the religious, that's just nonsense. It's a federal holiday.
Well,
it's just nonsense.
As you know,
but I'm glad. Actually, I'm very glad to have actually had the stated opinion of our esteemed city manager.
well, it wasn't the opinion, it was so much the policy that the council had adopted.
Well, okay, then the policy of the council.
Okay.
Well, maybe the council's different now. Maybe the council might want to take another look at it.
Well, as you know, we can't take action tonight, but we'll take it
No,
under advisement.
that's why I
Thank you.
asked.
Okay.
I thought you could do it. Just change it and get a campaign boost, but.
Okay, thank you. Anyone else have items that they'd like to address with the council that are not on this evening's agenda? No one else? Then we will move into the next item, which is a public hearing, and it's on Ordinance 482, amending the Clayton Municipal Code, Chapter 6.04, to adopt by reference the Contra Costa County Animal Control Code.
Thank you, Mayor Hayden and members of the council. As you recall, at your last meeting on June 19, 2018, you first introduced this ordinance and requested that we set today as the public hearing date for the council to consider adopting this ordinance by reference. We have set the public hearing and we have properly noticed it. So what is before you, again, is several county ordinances relating to animal control services as the county provides those services to the city. Some of these ordinances, for example, ensure licensing of domestic animals, provide for the impounding of large animals, provide for rabies control, registration of wild or exotic animals, regulation of dangerous and potentially dangerous animals, amongst other miscellaneous provisions. So we're recommending that you open the public hearing, take any public testimony that you may receive, close the public hearing, and then have the city clerk read the ordinance by title and number only, and then upon that, adopt the ordinance 482. I'm happy to take any questions you may have.
And again, then, for clarification, because we use the county animal services, the intent is to have consistent ordinances that can be applied consistently throughout that region.
Correct. And they're asking for all the cities who they provide that same service to adopt these same ordinances so that there's one set of governing rules for all of the cities that the county provides this service for.
Okay. Any other questions to staff? Okay. We'll open this up to public comment. I do have a comment card from Ann Stanaway.
Good evening. I'm Ann Stanaway, 1553 Haviland Place in Clayton. And I applaud the city's consideration of amendments to Contra Costa County's Animal Control Act. The act, if adopted unabridged, would constitute a conflict of interest for each member of the city council. The County Act, as written, allows anonymous reporting of code infractions. This irresponsible use of public funds must be stopped. Currently, the Act can be abused by persons filing meritless claims while hiding malicious private agendas behind a county guarantee of anonymity. Let County Child Services be our model. They collect contact information for all complainants upon first contact. Without such information, criminal cases cannot be prosecuted. Worse, law-abiding citizens and their pets can be victimized for purely private gain at the public's expense. The city must not suborn private gain from public resources. Any member of the council found to support frivolous usage of services provided under the adoption of the Contra Costa County Animal Control Act would be in violation of their oath as the city's responsible manager of public resources. Thank you.
All right. Anyone else wish to comment on this item? Seeing no one, then we will close the public hearing and bring it up to the council for discussion.
I would move to have the city clerk read ordinance number 482 by title and number only and waive further reading.
I'll second.
Been moved and seconded then that the county clerk read the ordinance by title and number only. All in favor?
Aye.
Anyone opposed? No?
Ordinance number 482, an ordinance amending Chapter 6.04 of the Clayton Municipal Code to adopt by reference the Contra Costa County Animal Control Code, including county ordinance numbers 80-97, Revised Animal Control Ordinance, 83-10, Animal Control Ordinance Amendments, 85-23, Animal Services Contracting, 87.74, Regulation of Dangerous Animals and Potentially Dangerous Animals, 97-33, Penalty for Abandonment of Animal, 2005-24, Dangerous Animals, 2006-5, Amendment to Dangerous Animal Ordinance, 2011-8, Spaying and neutering dogs and pounded dogs prior to release, 2011-9, Microchipping impounded dogs and cats before release, 2016-2, exemptions for animal license fees, and 2017-12, amendments to Division 416 Animals of the County Ordinance Code, and adopting penalties therefore as provided in County Ordinance numbers 97-33 and 2017-12.
All right. I would move adoption of ordinance number 482 with the finding that the adoption does not constitute a project under CEQA, and this activity will not have a significant effect or physical change to the environment.
Second.
All right. It's been moved and seconded then that the council adopt ordinance 482 as proposed with the findings that the adoption would not constitute a project under CEQA. All in favor?
Aye.
Aye. Anyone opposed? No? All right, it is approved. This was discussed at our last meeting, so that's why there wasn't a lot of discussion this evening. Next item then would be 7B, and this is a public hearing to consider the introduction and first reading of ordinance number 483, amending Title 17 zoning of the Clayton Municipal Code to restrict and regulate parolee homes in the following general plan designations: multifamily low density, multifamily medium density, and multifamily high density, subject to a conditional use permit. Presentation by our Community Development Director, Mindy Gentry.
Thank you. Good evening, Mr. Mayor and City Council. First, I'd like to provide a quick overview of the staff report, which will be segmented into three main topics. The first element will focus on the history and background of why this ordinance is being proposed. The second portion will focus on the nuts and bolts of the actual ordinance. And then lastly, there'll be a presentation to the Council of Alternatives. So issues of overcrowding and recidivism have been percolating in California prisons for well over a decade. Oh, sorry. Okay. So
Push it down so it's into your mouth.
Okay, so issues of overcrowding and recidivism have been percolating in California prisons for over a decade. In 2006, Governor Arnold Schwarzenegger declared a state of emergency with regards to the state prisons. At the height, California was housing over 170,000 inmates with only a design capacity of approximately 80,000 inmates. In May of 2011, the United States Supreme Court determined California's overcrowded prisons were a violation of the Eighth Amendment's ban on cruel and unusual punishment, which resulted in the Supreme Court mandating that California reduce its prison population by more than 30,000 inmates, or 0.5 of design capacity within 2 years. So California had several options to comply with the court-mandated reduction, such as new construction, transfers out of state, and or using county facilities. The state legislature chose to relocate a portion of its prison population to county facilities through the passage of Assembly Bill 109, or also known as the Public Safety Realignment Act, which went into effect in October of 2011. The passage of AB 109 really represented a significant and massive change to the California criminal justice system. AB 109 prospectively transferred the responsibilities for supervising and housing specified inmates and parolees from the California Department of Corrections and Rehabilitation to each of the counties with a goal to reduce recidivism. Under AB 109, it allows newly convicted low-level offenders to serve one sentence in county jails instead of state prisons. AB 109 also expanded the role for post-release supervision, which is also known as parole, by enacting a larger reliance on community-based punishment programs in order to reduce recidivism. These programs included community-based residential programs, mandatory community service, home detention with electronic monitoring, day reporting, mandatory residential or non-residential substance abuse treatment programs, amongst others. California has one of the most expensive prison systems in the entire world, with the current average cost of about $71,000 per inmate per year. And those costs are going up to approximately $80,000 under the current state budget. Due to these exorbitant costs associated with housing inmates and those costs rapidly increasing, California is steadily moving away from its public policy of incarceration. For example, Propositions 47 and 57 reduced the penalties for some crimes from felonies to misdemeanors and increased the use of parole and good behavior opportunities for felons convicted of nonviolent crimes. These two propositions have decreased the number of inmates being incarcerated through the reclassification of crimes, as well as the use of alternative custody options such as parole. Both at the federal and state levels, the trend and the push has been to decrease the country's incarceration rate, which is the highest of any nation worldwide. There has also been a shift from incarceration to parole, which redirection results in more community-based supervision. This paradigm shift from mass incarceration places a greater burden at the local level, and Clayton must be better prepared for anticipating these individuals within the community. In response to AB 109, the Board of Supervisors initially adopted the Contra Costa County Realignment Implementation Plan. One of the outcomes of the implementation plan is to provide a system of alternatives to post-conviction incarceration to not overburden the county jails. Therefore, these individuals will be realigned to be living within the community rather than serving time in jail. According to the county's Public Safety Realignment Report for fiscal year 16-17, the county has focused on formalizing partnerships between different law enforcement agencies, health and social services, and community-based organizations. These partnerships have resulted in a higher number of referrals to reentry support services. There were also key changes and refinements to the county's approach to AB 109, which increased investments in housing services. The annual report further acknowledges the county will need to undertake a comprehensive planning process in order to guide the county's parole reentry system as a whole, not to just those individuals under AB 109. Therefore, there will be expanded access to AB 109 funded services to any returning resident to Contra Costa County. This expansion will result in an increased demand for housing and services beyond the requirements of AB 109 for these individuals. Clayton City staff reached out to the Sheriff's Office as well as to the Office of Reentry and Justice for additional information for the Council to consider. ORJ was created in 2017 as a 2.5-year pilot program to align and advance the county's public safety realignment, reentry, and justice programs and is mainly funded by AB 109. ORJ provided that there are currently 5 parolees with addresses in Clayton, which are actually far fewer than many other communities within Contra Costa County. ORJ has acknowledged a lack of information for individuals on probation by jurisdiction. However, there are individuals in Clayton under juvenile supervision, court supervision, and traditional probation. No individuals under AB 109 are currently reporting a Clayton address. Additionally, ORJ staff provided that the county does not directly operate any residential home for parolees, but the county relies on community-based programs for the provision of these services and housing. In reviewing the budget for AB 109, the county is currently housing some inmates under alternative custody scenarios such as placement in shelters, recovery residences, and residential treatment facilities. The county currently houses individuals at 5 locations in Concord, 3 in Antioch, 2 in Pittsburgh, 1 in Bay Point, and 1 in Martinez. These facilities are typically operated by a community-based nonprofit organization. Staff from the Contra Costa County Sheriff's Office has indicated these type of alternative custody placements will only be more prevalent due to the increasing cost of housing inmates in the county jail, the shift to lower level offenders not being incarcerated, and AB 109 services being expanded to all parolees and probationers that are Contra Costa County residents. Therefore, it is anticipated there will be an increase in these types of residential uses catering to parolees, which can conceivably locate in all communities, including Clayton. ORJ staff also indicated there are several private organizations that run homes for the parolee probationer population that operate under the radar because they are considered to be communal living and they do not have to report their existence. The proposed ordinance would prevent these organizations from flying under the radar within the city of Clayton, and simultaneously it would restrict their location and regulate how they operate, as well as require these private organizations to apply for a city use permit. On May 22nd, 2018, the Planning Commission held a hearing and recommended that the City Council deny the ordinance, which would result essentially in the City Council not taking any action and maintaining the status quo. Over 20 speakers addressed the commission with such comments as the city should ban parolee housing outright, slow the implementation of the regulation of parolee homes, consideration should be given to increasing the buffers, and the adoption of the proposed ordinance would only be inviting parolees to locate in Clayton. So what's the current status? The Clayton Municipal Code is currently silent and does not address parolee homes. Therefore, under present conditions, if an organization, individual, and or state or county grantee sought to locate a parolee home within the city of Clayton, the use would be permitted by right, which means a parolee home would be able to locate in any residential district without a buffer between it and a sensitive use, and would not be subject to any regulations or controls beyond those of a typical residential use. On August 5th, 2016, the city received an email from a nonprofit county grantee searching for a facility where a use permit would not be required in order to operate a transitional housing program to assist individuals that had been previously incarcerated as part of the Contra Costa County Reentry Program. This email prompted city staff and the city council to immediately adopt an interim moratorium to prevent any parolee homes from establishing within Clayton. The moratorium is set to automatically expire in October of this year, and staff is now returning to the City Council with a proposed ordinance for consideration to appropriately restrict and regulate these types of land uses. To be clear, even though staff did receive an inquiry back in August of 2016, there are currently no requests or applications for parolee homes that have been submitted for consideration or are pending upon the expiration of the moratorium. The operator that originally inquired about the placement of the parolee home subsequently opened a facility in the city of Pittsburgh. Therefore, there's no current interest from that particular organization. Should the moratorium expire without a regulatory ordinance in place, there is no foreseen immediate risk that staff is aware of. However, there could be a long-term risk if the City Council does not take action restricting and regulating this land use. Clayton does not have any control over how the state or county manages, directs, and supervises correctional and rehabilitation services. However, Clayton does retain control over its land uses. This shift at the national and state level to decrease mass incarceration, the flux and fluidity regarding correctional services at both the state and county level due to the mandated reduction of the state prison population, along with the county's implementation of AB 109, coupled with the inquiry from a county grantee for housing services, have each raised questions and concerns about the city's vulnerability regarding the placement of parolee housing within Clayton. Clayton does have several inherent factors which highly decreases the likelihood of parolee homes locating here. The first one is that there are a low number of parolees originating from the community because state law does require the formerly incarcerated to return to the communities of their last legal address. Secondly, there's a lack of convenient access to public transit. Third, there's a lack of rehabilitation services and programs. These services and programs tend to establish in communities with higher rates of parolees such as Richmond, Concord, and Antioch. Fourth, there's a high cost of housing and land in Clayton. And lastly, high rates of owner-occupied homes, which drastically reduces the possibility of a property owner renting a residential unit to such programs. Even with all of those factors that decrease the likelihood of parolee homes locating in Clayton, city staff has highlighted a vulnerability in the city's existing municipal code. Clayton does not have some of the protections in place that other cities currently have regarding a larger breadth of land use classifications, such as group housing, to rely upon in order to regulate these uses. In fact, Clayton's group housing regulations exempt parolee homes and are less restrictive than the proposed ordinance to comfortably rely upon for parolee housing. So now we're going to take a look at some of our neighbors to see how they are managing parolee homes. Pleasant Hill classifies parolee homes as unlicensed care facilities, and they require a use permit in all zoning designations. These facilities do not have any operational regulations or buffers in place. Therefore, Pleasant Hill currently has more restrictions than Clayton does now, but is less restrictive than the proposed ordinance. Walnut Creek classifies parolee homes as congregate care facilities or group residential. Congregate care facilities are prohibited in single-family and duplex zoning districts and require a conditional use permit in multifamily districts. Group residential is prohibited in single-family and duplex zoning districts, but are permitted by right in multifamily zoning districts. These facilities do not have any operational regulations or buffers in place. Therefore, Walnut Creek has more regulations in place currently than Clayton does, but is less restrictive than the proposed ordinance. Danville classifies parolee homes as group homes and are permitted by right with 6 or fewer residents, and requires a permit if there are 7 or more residents. Danville only has slightly more restrictions in place than Clayton currently does, but the regulations are less restrictive than the proposed ordinance would be. Lafayette does not have any regulations pertaining to parolee housing, so they are in a similar situation as Clayton after the automatic expiration of the moratorium. The lack of regulations in Clayton means that the proposed ordinance would be more restrictive. Concord classifies parolee homes as group housing, which is prohibited in single-family residential zoning districts and requires a conditional use permit in their higher multifamily residential designations. These facilities do not have any operational regulations or buffers in place. Therefore, Concord has more regulations in place than Clayton currently does, but is less restrictive than the proposed ordinance. Oakley had a council member attend a training and directed their staff to draft an ordinance addressing parolee housing, which was adopted back in 2014. The regulations in Oakley are similar to the proposed ordinance by only allowing them to locate in 2 multifamily zoning districts subject to the approval of a use permit. Oakley also adopted operational regulations and buffers adjacent to sensitive uses. No inquiries have been made to the city of Oakley regarding the establishment of a home for parolees. Pittsburgh classifies parolee homes as a group home and are allowed in multifamily zoning districts subject to a use permit and are prohibited in single-family zoning districts. The planning staff in Pittsburgh has not taken any specific action regarding parolee homes, but revisions to its code to manage these types of uses is on their radar for consideration. These facilities in Pittsburgh do not have any operational regulations or buffers in place. Therefore, Pittsburgh has more regulations in place than Clayton currently does, but they would be less restrictive than the proposed ordinance. Antioch has adopted an ordinance in 2014 restricting and regulating parolee homes, which they classify as a correctional facility. Correctional facilities are only allowed subject to the approval of a use permit in the industrial zoning districts and have adopted regulations and buffers around sensitive uses. Antioch's ordinance is more restrictive actually than the proposed ordinance due to a larger geographical region and a larger variety of land uses. In summary, each jurisdiction that staff looked at classifies and deals with parolee homes differently. However, the majority of jurisdictions have some type of land use classification that addresses communal living situations. Most of the surveyed cities require a use permit, which is a greater regulation than what currently exists in Clayton. Presently, these uses would be permitted by right in Clayton and not subject to any regulations beyond a typical residential use. By directly addressing the issue of parolee housing through the adoption of the proposed ordinance, Clayton will be more regulatorily restrictive than its surrounding neighbors. Let me highlight that again, that the adoption of this ordinance will result in Clayton being more regulatory restrictive than its surrounding neighbors. So now that we've established the background as to why the ordinance is being proposed and what the process has entailed, I'd like to now provide an overview of the details of the ordinance itself. The proposed designation where a conditional use permit could be applied for would be in multifamily low, multifamily medium, and multifamily high density general plan designations. There are 6 areas with these designations. Due to Clayton's small size and given it's mostly residential in nature, there were limited areas for consideration. Multifamily designations were ultimately recommended due to a limited variety of land choices. Multifamily designations represent a smaller geographic area, the proximity to arterial streets, and would provide a minimum number of locations parolee homes could locate and not be legally questionable. So up on the screen are the areas where the multifamily residential districts are located. Up adjacent to Crooker Pass Road is one. That one would actually be the buffer zone that's proposed in the ordinance. The one would not be able to locate there because the Clayton Presbyterian Church actually has a daycare on site, therefore would not be able to locate at that location. Secondly, there's this location up here, and then the others kind of hover around the town center. Also with the 500-foot buffer,
That location up there, no. You just kind of said that was.
there's this location up here as the secondary, as a,
Where is it?
it's up, so this is Sino Hill here, and this
Excuse me,
is,
the audience will have an opportunity to make comments. Let's get through the staff presentation first. I think you'll understand it better.
This
Okay.
is Eagle Peak here, and Keller Ridge kind of goes along this particular area here.
That's the condos.
Yes, those are the condos up off of Keller Ridge. This is the old fire station site here. This is the vacant property behind the post office and along Marsh Creek Road. And then these are housing developments off of adjacent, the libraries right here, and this is Oakhurst. With the 500-foot buffer, this would also preclude the old fire station site, which is the closest to the elementary school, from locating there because of the buffer would conflict it out, essentially. So that would leave these four designations as possibilities. So following the Planning Commission hearing, staff conducted additional studies and in consultation with the City Attorney's Office, refined its proposal to increase the buffer for sensitive uses that was originally contemplated at 300 feet to a recommended distance of 500 feet. The 300-foot buffer was based on consistency with the existing buffers contained in the municipal code, but given the high recidivism rates and the input provided from the community, staff reviewed the differences between the 300 feet and the 500-foot buffer, and staff feels that the larger 500-foot buffer is justified. And also this map here is zooming in on the downtown area. So frame of reference, this is the old fire station site, the elementary school, the library, and all of these red polygons represent the sensitive land uses within the ordinance. Whether there's on sale or off sale of alcohol, whether or not it's a park, those are all of the areas in the downtown. So the 500-foot buffer again would preclude that and would further encroach on this particular neighborhood here, and then would also come further down to the south on these particular properties here. So after conferring with the City Attorney's Office, the feeling was that this change in the buffer distance would be legally defensible, given that there are still 2 to 3 feasible locations where parolee homes could possibly locate, as opposed to the 3 or 4 that were previously recommended. The proposed parolee housing regulations would be subject to a conditional use permit in the multifamily designated areas that I just mentioned. As a use permit process consists of a public hearing process whereby the community would be notified of the proposed use. The use permit application would then be subject to a public hearing and a discretionary review by the city's planning commission. Not only have locational requirements been proposed, but there's also numerous objective standards have been incorporated into the ordinance to mitigate or minimize any impacts. A parolee home cannot be located within 500 feet of any school, daycare, library, park, hospital, group home, a business license for the on or off sale alcoholic beverages, or emergency shelter, amongst a few others. It also must not be located within 1,000 feet of another parolee home. On-site supervision would be required 24 hours a day as part of the use permit. And as part of the use permit application process, the ordinance would require additional information such as the client profile, maximum number of occupants, and a management plan. Lastly, multifamily housing projects with 25 units or less are limited to 1 parolee housing unit, and housing projects with 25 units or more are limited to 2 parolee housing units. These thresholds would be applicable in apartment and condominium style buildings. So the council has 3 options to consider this evening. The first option would be to regulate parolee homes by adopting the ordinance as it's currently drafted, which is the most legally defensible option while still providing the community with a level of protection for public safety. The ordinance also removes the vulnerability gap contained within the Clayton Municipal Code because the city currently lacks a mechanism to address this land use. Council could also direct staff as part of this option to amend the ordinance For example, council could direct staff to consider different zoning designations that would be acceptable, or maybe to make changes to the regulations or to the buffers. The second option for the council to consider would to not take any action and maintain the status quo. This would allow parolee homes to be located in any residentially zoned area within the Clayton city limits without any land use regulations or development standards, located adjacent to sensitive uses, and without a public hearing process. This would also leave the city without legal grounds in place to remove these homes if one were to be established in the city subsequently were to adopt regulations. The parolee home would effectively be grandfathered in. And the third option would be to direct staff to draft an ordinance banning parolee homes from operating within Clayton. It should be noted that no other city within Contra Costa County has chosen to ban parolee housing. This option could result in legal exposure to the city. There is no law specifically prohibiting a ban on parolee housing or legal precedents. However, given the fact that the Supreme Court has mandated California reduce its prison population and the state summarily enacted AB 109 as law, city staff and legal counsel have serious concerns whether a ban would prevail in the courts. The legal cost would be significant for Clayton, which is a small city with limited resources. In terms of public policy, if more cities were to start to ban parolee housing, it would then make it difficult for the state and subsequently the counties to fulfill its mandated obligation under AB 109 to manage the incarcerated populations, thereby placing the state in a position to either pass legislation forcing cities to allow parolee housing and or will result in a lawsuit challenging those cities that have prevented the placement of parolees. Further, such local prohibition would not preclude civil rights organizations from filing a lawsuit such as the ACLU, which is well aware of realignment in California. Civil rights groups are paying attention to local government actions in this regard, and the ACLU is not at all reticent about filing lawsuits. So given the shift to decrease mass incarceration, the larger and increased reliance on community-based supervision due to the mandated reduction of the state prison population, along with the county's implementation of AB 109 and Clayton's lack of regulation, staff is recommending that the city be better prepared to anticipate these individuals in the community. Also, given the legal concerns regarding a ban on parolee housing, staff recommends that the City Council motion to have the clerk read ordinance number 483 by title and number only and waive further reading. Then motion to approve ordinance 483 for introduction to restrict and regulate parolee housing to multifamily general plan designations subject to a use permit. Before I turn it back to the council for questions, I would also like to introduce Ms. Patty Grant, who is here from the Contra Costa County Sheriff's Office. She's in the audience this evening in case the City Council has specific questions regarding the county's custody program as well as the implementation of AB 109. Thank you. That concludes my staff report.
Any questions of staff at this time for clarification? Do you?
I do have a number of questions, and some of them are just clarifications. So question number one is, we are currently effectively regulating parolee housing by having an interim ordinance, an interim moratorium in place, and that's governed by the government code section that you cited in the staff report. The government code also imposes time limits. I mean, it does allow a full moratorium under the interim ordinance, but it does have time limits. So the question is, why can't we just adopt another interim ordinance? I think we've exhausted the time limits, but can you confirm that that is the case?
That is correct. The city has exhausted all of its options under the government code, and it will be automatically expiring on October 3rd.
Okay. So then my other question is, in your staff report, I think it was on page 8, you mentioned that at this time, staff does not have any pending applications or requests that would be waiting for the expiration of the interim ordinance or moratorium on October 3. So my question is, I guess, absent any action from us tonight, I mean, you would not actually need any application. So in other words, come October 3, if we don't do anything, those types of uses are principally permitted, so you wouldn't even have an application on file.
That's correct.
So, and if I was, I guess I could add that if I was an entity who wanted to locate parolee housing in our city, I probably would not be knocking on the city's door at this time, and I would wait until October 4 and just go in at that point.
Correct.
Sorry, so that's one observation. So then the other question is, so absent, once this current moratorium expires on October 3, if we do not do anything, it was mentioned that the parallel housing would be principally permitted, and I wanted to understand a little bit as to how that would be the case. So I looked a little bit, and I just want to confirm that my understanding is correct. So I looked at some of the different definitions that we have in our zoning ordinance, and I think, if you look at our zoning ordinance, there's no definition for parallel housing as of today, so you cannot find it. So if I was an entity interested in that, I think I would try to see, can I fit it into any of the existing categories? And we have categories, for example, for supportive housing and transitional housing that are permitted in some districts. The supportive housing, I think, was type of housing that is occupied by certain target population that's linked to an on-site or off-site services that assist supportive housing resident in retaining housing or improving health and whatnot. So is that why it would become principally permitted, is because that the parallel housing would end up becoming part of one of the existing use categories?
Essentially, it would be permitted is because our code doesn't address it. It's silent. So it would just be basically considered like any other type of residential use, and wouldn't be looked at any differently.
Okay. And I personally, from my personal experience, I would argue that you could probably make it fit into one of those other categories, possibly, or at least a land use attorney might make the argument that you could fit it into something else that already exists. So then I have a question maybe to the city attorney, and you may not have an answer to this. So one of the options obviously would be to prohibit parallel housing altogether. That obviously risks the city to a lawsuit. So I'm trying to sort of gauge, and I don't think you probably have an answer to this, but what's the likelihood that the city would prevail in a lawsuit like that? Obviously, I think that would be sort of a lawsuit of a first impression. There are no other lawsuits on this matter. I think you can probably think of other topics, where something like this has gotten tested, but I don't know if you wanted to share any other thoughts on what might happen.
Yes, it would be a case of first impression. As you can see from the staff report, both the oral staff report and the written staff report, I think there's a real reason why most cities who are dealing with this are regulating it and not banning it. I think it is strongly defensible to regulate it, as we've done in the ordinance. We're trying to deal with public health, safety, and welfare issues and the secondary impacts of parolees. However, I think banning it could really put us in a very difficult position to defend it. So in light of all of these risks, we think it is best to regulate it rather than ban it. And we feel strongly about that.
Okay. And then I have two more questions. So one of them is, so I definitely appreciate the history in kind of how we got here. I understand, we had a Supreme Court case that really addressed the prison overcrowding, nothing that we as the city have any role whatsoever in. I understand that there was a state legislation that addressed this. Then there was also a couple propositions that were on the ballot, but that all of us in the city of Clayton also voted on. I think one of them was Prop 57 in 2016. I actually looked up the stats for the city of Clayton because I was curious to see how we as the city voted. Obviously, it passed on the state level, but Prop 57 was the one that allowed certain types of felons to be considered for parolees. So essentially, I think relaxed it in that way. In the city of Clayton, Prop 57 passed with 3,740 yes votes and 2,607 no votes. So the vote was about 60-40 split. So as a city, we voted also in favor of that. But now here we are. So, and I think my question is, and again, this may not be a question where you have an answer to, but given everything that's going on, do you see any possibility or anything on the horizon that would reverse this trend? In other words, the states or the federal, are we building more prisons? Is this becoming less of an issue? I mean, I think I know the answer, but is there anything else that we're aware of that could take us to the other direction where we really don't need to address this as a city?
All of the research that's been conducted, as well as conversations with the sheriff's office, it's going more and more towards decreasing mass incarceration and going towards community-based supervision. And even there's a Senate bill in committee currently at the state legislature to essentially when those that have been arrested for a crime for waiting for pretrial, that it will essentially eliminate any bail requirements. And they would be serving essentially, if they meet the criteria, they will essentially be awaiting trial in the community rather than in the county jail. So the trend is going in the opposite direction towards community supervision.
Got it. Okay. And then my last question is, so the proposal that staff has presented to us is to regulate this matter and to require any parolee home to obtain a conditional use permit. And I wanted to see if you could elaborate a little bit more about what does it mean to be principally permitted versus be subject to a conditional use permit. And as I was listening to your staff report, I actually pulled up our municipal code, pulled up the section that addresses conditional use. I mean, there's a long list of standards of review as to what the Planning Commission has to find when it grants a conditional use. Everything from there are some crime factors as to whether a project could possibly result in a significant increase of crime in the area. The Planning Commission will have to make certain findings about the use will not negatively affect the general safety, and on and on and on. But can you, so there's definitely a number of criteria, a number of findings that a commission would need to do before it grants a conditional use permit. Can you address the notification part? What does it mean? I mean, there's a hearing, but how do the citizens get notified if there is an application for conditional use, and kind of how that works?
So if a community based organization submitted an application to the city for consideration for a parolee home, and the ordinance was in effect, then the city staff would analyze it as you indicated and, look to see if the application could meet the findings that are located in the municipal code under the use permit as well as contained within the ordinance. And the notification that would occur would, depending on the location, all of the property owners within a 300-foot radius would be notified that this use was being proposed and considered in front of the Planning Commission. There would also be a notification in a newspaper of general circulation ahead of time, as well as posting on the city's 3 community posting boards. And then the night of the Planning Commission meeting would be the time for the public to come down to basically comment on whether or not the application is a fit.
And when you have the Planning Commission hearing, the commission obviously, after they hear the public testimony and review everything, they themselves have to obviously make those findings, they take a vote, and there are also additional conditions that the commission could impose on any particular application.
Correct. The Planning Commission has the ability to provide additional conditions of approval, and regardless of the decision of what the Planning Commission decides, that decision is always appealable to the City Council.
If I might, Councilmember Catalano, maybe you were headed this way as well, but in addition to regulating the front end of a conditional use permit, those conditions have to stay in place, and the operator must meet those conditions, or a conditional use permit is subject to revocation or to be revoked for violation of that. So that's another advantage, is you not only regulate the front end, but also the back door.
Got it. Okay, that's it for me.
An observation regarding the trend of this type of legislation. As a member of the Public Safety Policy Committee of the League of California Cities, every quarter we see a new list of legislation that your legislature and administration in Sacramento continually bring forward more legislation to increase this so-called realignment and however they wish to glorify and characterize it. And that body of 60-plus people, the majority are either current or former law enforcement. We always put forth, after listening to all of their arguments, recommend that we vote against it. So we're trying to stem this, but it's really becoming a challenge. I'd like some clarification on a couple of the things that you mentioned relative to Clayton specifically. In your report, you stated that there were approximately 5 realignment members currently in Clayton, yet you also stated, I think, unless I misunderstood, that there are a number that have not listed Clayton as our address. So there seems to be a conflict there.
So to clarify, there are currently 5 parolees living within the city of Clayton. None of them constitute and fall under the umbrella of AB 109. AB 109 actually only comprises about 5% of the county's inmates. And then the Office of Reentry and Justice has stated that they do not have numbers for those that are on probation by jurisdiction. And so just to clarify what the difference of parolee versus probationer. So typically parolee is somebody that's going to have served their time, have been released, and are ongoing serving the rest of their sentence, but they're on parole. And probation is usually somebody that has been identified by the courts, not serving any jail time, but some type of alternative scenario.
Okay, but they are not living in a group home someplace.
No,
they're in an individual residential unit.
Correct.
That somehow they qualify to
their last known residence.
Or somebody's providing them funding to reside here in Clayton.
It might not even be funding. It could be family. It could be family housing that individual.
There's no congregation of more than one in each of these individual units that you've identified or been able to identify.
No, not that we know of.
Thank you. But it appears that outright banning is not a positive option for the council. Because if we did that, then we'd be subject to most likely future litigation. Although it would be a risk if we were to outright ban. Is that correct?
That's correct.
Thank you.
Is that all your questions, Jim? What? Julie?
I will just say that Tuya asked virtually all the same questions that I had on my list, and so I think it's really clear, at least to me, and I'll be interested to hear now that the public understands what the options are and what the ramifications are. Hopefully they will understand, as I do, that if we do nothing and leave the code as it is, there could be a home established next door to any one of us, and we'd never know it until there's a problem. There'd be no conditions, no way to get rid of it if there's a problem. So personally, excuse me, you guys get your chance to talk in a minute. I think, I'll just say right up front, I'd rather know about it and discourage it by being extremely transparent and have lots of notice about a process going forward, so that any prospective home can hear from all of you when it wants to make its application, and not just us or not just nobody, because something that flies under the radar, as the folks who wanted to come here 2 years ago wanted to do, is not my idea of what this community wants. I think this community wants to protect itself by knowing what's happening in each and every neighborhood. So that's just my comment. I'm looking forward to the comments of the public, and then I will have a statement afterwards.
So no questions of staff at this time?
Nope. Tuya did a great job.
All right. Well, Tuya did raise most of the questions I had, but I just wanted to clarify a couple of things. Obviously, we're protected now, but only because the moratorium is in place and it is due to expire, and when it expires, then we're open to potential development, and if we take no action, that development wouldn't have to notify us, there would be no hearings, people would be able to just move into Clayton and take advantage of that moratorium expiring, correct?
Correct. I would classify it more as not development, but moving into an already existing location.
Okay, but moving parolees into the community.
An organization would be able to establish a home without regulation.
And again, without a public hearing, without permits, without any notice required.
Correct.
Okay. And so the other option then would be to prohibit it. We've already talked about that. But I had a question about, you said no one currently in Contra Costa County is prohibiting this type of use.
That's correct. No city at this point in time has done a ban.
Okay, so the question is, those are the two extremes, taking no action or prohibit, neither of which appears too attractive to us, doesn't protect the city long-term, it sounds like. So the other option then would be to adopt restrictions that give us that control over what happens in the housing in our city. And I did hear you say that you looked at the conditions that were proposed for the Planning Commission to review, and you expanded the buffer zone from 300 to 500 feet?
Correct.
To provide some more protection. Why didn't you go further? What would be the drawback to expanding that to 800 or 1,000 feet?
The further expansion of the buffer would essentially be a ban through exclusions. It would get to the point where you would no longer have any possibility of the location, so effectively it would be a ban.
Okay, and that could be challenged rather easily?
Correct.
In the
That would
courts.
be the same effect as just banning it outright. It would be
Okay.
a de facto ban if the buffers in itself created no options for someone to.
So that's why you felt that 500 is more reasonable and defensible?
Correct.
Okay. And it does sound like we should expect that there are going to be more parolees being released as the state concept of dealing with the prison issue. So it's in our best interest then to protect Clayton by implementing and adopting restrictions that give us that local control. That's why this ordinance is being proposed?
Right, it would be a proactive approach, for the city to have something in order to regulate, yes.
Okay. Any other questions?
I did have one just to clarify. When you were talking about distances, that's what reminded me. The noticing distance of the 300 feet, I believe that's a standard noticing distance for any kind of use permit in the city. Is that correct?
Yes, that's, I believe, part of the government code.
Could that be expanded to the 500 feet or something like that for this use? Or would that be discriminatory?
You're just talking about notice to the public?
Right, the notice to the public.
That'd be fine.
That would
You
be
can always
okay.
give more notice, so that isn't a problem.
Okay. And there would be no reason that, well, this would obviously be put on the city's website as part of the agenda. But we could do some kind of a call out on the front page of the website or something like that about a public hearing or something, if we wanted to. Okay. Thank you.
Reminded me of something also. If we took no action and we discovered, again, because we're not notified now if we had taken no action, of a parolee living within our community, would we be allowed then, after the fact, to go in and take action on a housing arrangement that does involve parolees and restrict or prohibit it after they've moved into the community?
If the home is already established, it would effectively be grandfathered in. The city would have no recourse or legal grounds to remove it from the community.
So we have to deal with that up front.
Correct.
All right. Any other questions at this time? All right, we're going to go to public hearing. I have a number of speaker cards on this issue. The first one is Nancy, is it Ahern?
You have to excuse me, I don't do public speaking very well. I was with the Alameda County Sheriff's Department for 34 years. I have quite a few questions. One of my questions is, okay, you have a 500 foot. Are we building a building if someone requests this, or are you going to buy somebody out for the housing? Anybody? Can you answer that question?
Go ahead.
This is your 3 minutes to speak.
I know, I want to know. You aren't letting us just have questions, so this has to be part of what I'm asking.
Well, if a community organization or nonprofit, likelihood of them building something from the ground up, given the construction costs, is probably pretty unlikely to occur.
And we don't have to force somebody to sell their house for this?
Absolutely not.
All right.
Or
The
rent
question is, you're saying 500 feet from certain
You missed
people.
a comment, or rent it,
Rent it,
or
yes.
rent it.
Or rented, okay. Next question is schools. You're saying a 500-foot thing. What about the poor people that are next door to that house? What about our property values? Is this coming from the state? Is this coming from the county? Which is it? Can the state just come in and take over?
This would be essentially funds that would be granted by the county or by the state to a
So a
nonprofit
lot
who
of
would be
this is
looking to
talking
locate.
about money. A lot of this is about money.
There
That's what it boils down to. My other question is, we already have a farm out on Marsh Creek Road. We already have halfway houses out on that. Doesn't that count for something?
That is unincorporated Contra Costa County, not within the bounds of the city limits.
It's not in the city of Clayton.
Okay.
We're trying to protect what's occurring inside the city
Okay,
limits.
because I'm getting a lot of wrong information. I'm getting the impression that you guys are voting to have this. This meeting's telling me you're only trying to safeguard.
Correct.
Right.
Yeah, exactly.
Okay, because a lot of people think it's just, you're going to sit there and let them build wherever they dang well please.
That's a concern. That could happen today if we don't take action.
Okay, so all we're doing is trying to redo what we already have till October 3rd.
But we don't have,
But the issue we have will go after October 3rd.
it
So what we're trying to do
expires.
is safeguard from that.
Right,
Nothing else.
right. Once it expires,
You aren't promoting for parolees to come in?
No,
no, we're trying to protect us.
absolutely not. We're trying to
Well,
make
that's a
it
lot of what-
very open and transparent.
And I think it's kind of funny for you guys to say that we'll guard against parolees. We have parolees here.
Yes.
I mean, so does that mean if we safeguard ourselves and we do that, we can't pull them out? So we'll always have parolees here, no matter what.
The city cannot regulate how the county or the state manages correction and rehabilitation services. They are always going to be part of the community. However, the city retains control over its land uses and can prevent parolee homes from just establishing anywhere without any controls. That's what the city can maintain control over.
So in other words, whatever, through rental or build, that's the only way they're going to get in.
If somebody buys a house in the proposed districts that's being proposed, or rents out a house, it would be, or ground-up development, which would be highly unlikely, would be the only way. They would have to propose an application to come to the city, and it would have to be also reviewed and approved by the city's planning commission.
Okay, I'm not in any of the areas that are going to be affected by this. My question is, for those people, if you get one of them and it decreases their house values, do you go to sue the county or the city? I mean, the state. Because that will decrease their house values. And we work too darn hard not to be able to sell our house for what we want.
Well, do you have any more questions? I mean, that's what we're trying to protect against. Right now, there's no prohibition for someone being able to do that once this expires. So you'll all have an opportunity to come address the council. Are you through? All right. Next up would be Glenn Miller again. Not again. New issue. Sorry.
I guess I do have some questions. Could you put up a slide that talked about the number of units, please?
I'm sorry, I didn't hear that.
The slide that talked about the number of units, that, you know, it was either 25 is going to be 1 and greater than 25.
Oh, one of the last slides.
This one?
Was
That
this, so how many areas are zoned for 25 units or greater?
Go ahead.
Essentially, there is 2 locations. One would be prohibited from building with the buffer established, and then the other would be the location behind the post office and fronting onto Marsh Creek Road.
And how many houses is that zoned for?
The current base density is 20 units to the acre.
And how many acres is it?
There's roughly about 3 acres, I believe, that are...
It'd be 60 housing units. So that would mean just adjacent to the downtown, you'd have 60 housing units. I'm real slow with math, but I think that would be 4 or 5
No.
parolees.
No, because of the distance requirement.
If it's allowed, it would be limited to 2 parolee housing units, is the way it's
But
being proposed.
only if they're that
Okay.
far apart. There's a distance requirement in between them, too.
Well, I don't know how many 500 feet's in those properties. I just wanted to know. So in regards to money, You're saying that it would be prohibitive for somebody to come in as an organization and build the units. So we're basically looking at somebody coming in and buying a unit with some kind of subsidy. Is that correct?
To buy or to rent.
Buy or rent.
Yes.
Okay.
We're looking at a group housing approach is what we're really focused on.
Buy or to rent, yeah. And that would be associated with, if you pass the ordinance, that transaction would have to have a conditional use permit. Is that correct?
Among many other things,
That's
yes.
Correct,
Yeah.
yes.
And then if that person decided to sell that house, does the house in perpetuity then, the location in perpetuity, become a parolee housing unit, or does the conditional use permit go away with it?
If the home was not backfilled with another parolee home and somebody just from the community purchased that home, then it would have 6 months, essentially, that the use permit would be basically applicable to that piece of property. But if it were to lapse beyond that 6 months, then it would no longer be a parolee and have to go through the process again if it were to be.
So are we granting locations to specific parolees, or are we granting these locations to organizations?
It would be to an organization.
Okay. Oh, I see. So they're really not.
The organization
They're
would
really
have to.
not the property owners. The parolees would not be the property owners.
No.
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 Okay, because with property owners comes a certain set of values of keeping the property up and that kind of thing, and I'm sure some people are going to be wanting to address that. So I think that's, the other question I had is that you say you have a multifamily unit, and an organization wants to buy one of the units, and you guys approve it. Is that in addition to the set-asides for low-income housing? In other words, does that give you a credit, if you will, for low-income housing, or so one of these? So a development could then get not only a set-aside for parolee housing, which questions the value of that home, the homes in the development, and also would have to have a low income. So my problem I have with this is you're messing around with the big X, the supply and demand. You are choosing winners and losers when you're going into a development. If somebody wants to come in to a development and they want to buy a house, and you have these restrictions, the developer is going to pass on those restrictions to the other people in the units so he can be made whole. That's just a fact of life. That's just a reality, and that's what actually causes housing costs to go up. So I'm trying to understand why you'd be even considering that. I don't see why you just.
And it's not a restriction, Glenn. It's being used to address someone coming forth and asking for approval.
I understand that. I understand that. But once you've designated that property to an organization rather than a property owner, you've really changed the dynamic as far as the community is concerned. And that is a big concern that I would have, and I'm sure a lot of people here have that concern. So that's kind of why I was asking those questions. So thank you. I think you've answered my questions.
But if I might, Mr. Mayor, and Mr. Miller, understand that all the concerns that you just shared now would be in place and spread throughout the entire city in any residential district if we do nothing.
I understand that. Quite frankly, if I may, go back to my time on the Planning Commission when we were working on certain housing elements and those kind of things, and finding ways to creatively create a situation where it's almost virtually impossible to do these units. I suggest you go back to the drawing board and see if you can come up with a larger buffer zone, or make it have to be a 65 unit before you would even a development, before you'd even consider it, since I think what I'm hearing is that there is a potential for a 60-unit development.
Well,
right?
There's a piece of property that could have up to.
Right, and I'm just saying that if the potential for 60 units is that piece of property, first of all, you know and I know that they'll never get 60. They may get 40. You just raise that 25 until it's a point where it's, you know, it's nice. You can say you have it, but you're not going to build there. It's never going to be built in Clayton.
Well, again, we're not talking about something that the city would impose on a developer. This is someone coming forth requesting authority.
I understand, but if they're not going to build, it seems to be the consensus that nobody is going to come in and develop a unit as an organization because the costs being so prohibitive. What you're going to get is somebody trying to cherry pick on somebody's development. And the guy will say, oh, well, you know what, your ordinance says it is allowed. Well, if your ordinance doesn't allow it in that density or in that location, then they can come in and ask, but he's going to have to say, you know what, can't do it. So maybe you can get more creative and work on it that way.
Okay. Next speaker card I have is for John Grancy.
Mr. Mayor, Council, staff, I live at 3001 Coyote Circle here in Clayton. I've been there for about 4 years. My partner, Marcy Longchamps, has been there for 26 years. I'm a retired police officer, City of San Francisco, 34 years there, and I contract with the U.S. Marshal Service for the last 14 years. Personally, I have never seen anything positive come out of parolee housing other than recidivism. These people go back, they roam the neighborhood. Electronic monitoring means nothing to them. They put it on dogs, they put it on cats, and go about and do their business. There's no control over who comes into the property to visit, regardless of what their parole says, that they can't associate with other convicted felons. And please remember that a parolee, by definition, is a convicted felon. Marcy wanted to be here. She had a lot more to say than I did. And with your permission, I'd like to read a little notice that she put out or wanted to say. She goes on to say that I wanted to speak so badly tonight. Unfortunately, my health prevented me from being there. She underwent a medical procedure today that's just laid her low. I am a retired school teacher and a nana to my 2-year-old grandson. I strongly oppose any proposal which allows parolee housing into our community, and I will stand firm in opposing any measures or proposals that encourage the passage of this kind of thing. Our children, the elderly, all of us need to be protected and feel safe in our precious town of Clayton, and especially in our own homes. As I sat in the doctor's office today, I read one of the sayings posted on the wall and found it to be somewhat relevant tonight. It said, and I quote, "The purpose of life is to be useful, to be responsible, to be compassionate. It is above all to matter, to count, to stand for something, to have made some difference. It is my hope that I have made a difference to you tonight. Please, please do the right thing and listen to your constituents and hear what we have to say. And let me shout out to the huge thank you to everyone who has written to me and support and kindness. This is what our Clayton is all about." And she goes on to say, "I will see you all at the next Planning Commission meeting as well as the next City Council meeting." Thank you very much for your time.
All right, thank you. Next card is for Frank Gavidia.
Well, here I am again. Is this thing on? Good evening, members of the City Council and the City staff. Here I am again, here we are again. I think between Councilmember Diaz and Mindy just now, you basically made my case. An ordinance could end up in court no matter what. That's the reality. The ACLU loves to sue for everything. If they think we're being discriminatory, they're going to take us. My experience with most of the attorneys I've ever dealt with is they roll over. That's just how it is, and somehow the ACLU prevails. I think the thing that we're ignoring here is the fact that the market forces could solve this problem for us. Here's the Form 990 for the nonprofit that contacted you. Has anyone seen this? Well, these guys have less money than what he makes. They don't have the resources to come out here and rent. You basically nailed it. They would have to rent. I don't know who here in the audience would willingly rent their house to a bunch of parolees, or an organization that's going to have parolees there. I know I wouldn't. I certainly don't think any of you would. So all the ordinance is going to do is, here's the pass, here's the low bar that's set that can be challenged in court. Whereas the free market, if we do nothing, will take care of the problem for you. As Mindy said, who's come to do this? By the way, the email from this nonprofit here, specifically, she wanted to come here without a use permit. So they want to operate under the radar. I doubt that they could afford to rent anything here, unless they're going to pack 10, 20 parolees in a house. And then trust me, whoever that landlord is going to be dealing with all of his or her neighbors. And it's not going to be fun. Sometimes doing something, government, in a rush to do something, from our federal government, our state government, the laws of unintended consequences show up. I've seen it too many times from our federal government. We have to pass it to see what's in it. Lastly, we are in a state that refuses to obey the federal government. Why is this city in such a hurry to acquiesce to Sacramento?
Let the speaker talk, please.
Why do we want to acquiesce to Sacramento? We're a fiefdom right now in California. Hey, if we want to be strong, let it be a test case. When they see people here protesting, showing up signs, hey, we don't want this in our backyard. Do you want it in yours? Send it somewhere else. Clayton is a small town. I think we could argue that we simply do not have the resources, the space to have to deal with this problem. I noticed there were 2 cities that you listed in your proposal or in your ordinance report that have banned it outright. So why not us ban with those cities? Thank you.
All right. Just for clarity, were there 2 cities? I don't believe so.
And all of the research that the city staff did, Newport Beach.
In the county.
Oh, in the county, there were no cities that have banned it, but statewide, Newport Beach, which adopted a prohibition in 2008, and then I believe it was the city of Colton, effectively limited to 1 parolee in their boarding houses.
Okay.
And that was before the Realignment Act.
Yes.
Exactly.
Yeah. All right, one more speaker then on this issue, and that would be Brian Bedell.
There's one more speaker.
Okay.
Good evening, council members and everyone else. Once again, what I'm hearing is the city council trying to take the easy way out at the expense of the safety and concerns of the citizens of Clayton. The city attorney has admitted that this is a case of first impression. You don't know how this would come out. I'm not paying you, I'm not paying them to take the easy way out. If that means fighting for my safety, the safety of my family, and the safety of my city, I expect you to do it. I just read not 2 weeks ago in the Clayton Pioneer how flush the city of Clayton is with cash, that we could go for 4 years without collecting any taxes and we'd be great. I cannot think of a better way to spend that money than on legal fees challenging the state of California if, and that is a big if, they decide to challenge us on this. And if we blow through that, maybe Mr. Napper could cut his salary a little bit. Maybe Ms. Gentry doesn't get a 20% increase in her salary.
Excuse me, don't make this personal, just stay on the issue.
It's personal because I'm paying their salaries, Mr. Mayor. Here's the deal. There could have been other ways of doing this. In the League of California Cities that Commissioner Diaz just referenced, there's a recommendation, a template in there of a 1,000-foot radius. Why didn't you take that? Because it would be overly restrictive and be a de facto ban? Try it out. We don't know if they'll sue. If they don't sue, we're fine. If they do, we fight it. If we lose, we continue to fight it. That's the way we do. I'm a trial attorney. I made a career of fighting and winning. And if you people can't do your job, maybe we need someone who can, and that includes the 4 and 5 of you. I will say to the council members, and especially you, Mayor Hayden, you are up for re-election for November. take very cautious how you vote on this, because it will be an issue. I expect the safety of my city to be paramount when it comes to this. That is whether it's putting a senior center downtown, whether it is parolee housing, or anything else. That needs to be first and foremost, period.
All right, thank you. We have one other speaker.
Row is fine, everyone, up here. You need to start row is fine.
Well, you can address from the podium.
James Gamble, Prospector Place. First of all, Mr. Napper, if you pledged allegiance to the flag, you said the word God, and there's not any church and state separation there. And that supposed ban is fictitious. It was a letter from Jefferson to Danbury Baptist in Connecticut. So just for your own history lesson. First of all, I'm trying to figure out why the planning department is trying to push this, because it's obviously at this point not needed. It's going to encourage what we are supposedly supposed to be afraid of. We already have 5 parolees. I'm scared, okay? We've had 5. We've had 50, 100, what's it say there, 1964? How many parolees have we had in this town? And why do we have to get, all agitated and motivated? Because they're going to go put, 60, a big house with maybe 60 of them living in it? It ain't going to happen. And, and like Mr. Gavidia said, and like some of you have already admitted, the price of properties here is not conducive to that even happening. So there's no need for this, okay? There's no need for it. Ms. Gentry, did you figure the cost of the added police protection that's going to be needed, or that are going to be called to these properties potentially? And what is the clerical cost, overhead, and everything that's going to be added to the city for this? Do you know?
There will be no direct fiscal impacts with the implementation of the ordinance, because right now they can locate anywhere, so they can come regardless of whether or not an ordinance is passed.
And have they come in the last 50-something years?
This is a proactive approach because the public policy shift in California is to push parolees into community-based supervision programs and not serve out their sentences and be incarcerated.
Okay, so they hasn't. So moving on to my next point. So we don't know how much this is going to cost in additional police protection. We don't know how much it's going to take to manage it. I mean, we're going to have to probably hire somebody to go out and knock on doors or go check in with these organizations. How many are in town now? Do you know?
Staff is not aware of any homes.
Okay. Did you personally work on the Antioch regulations when you were in Antioch?
No, I did not.
It was already existing?
A different staff member was working on it.
Different one? Okay. I think I'm ready for my last question, which would be, did you call the police, Ms. Gentry, on people here that showed up for the Fulcrum informational meeting when there was no chairs in this area?
Excuse me, that's not germane to this particular issue.
No, but it is, because she's involved with this, and this is my non-agenda item.
You could have.
I would be happy to answer that question to set the record straight. I did not. The city actually received a credible threat, which is why the police were in attendance that night.
A credible threat? What was the credible threat?
I can't go into the details of that. But
why?
there was
a secret?
Come on. You got to respect.
So that means
there was a credible threat against the developers.
So then who would have called it? Who would have called for them?
The police officers were asked to be in attendance due to a credible threat that was given to the developers. So the police were not called by me or anyone, except they were in attendance to ensure.
If I come down, can I get that information? If I come down to City Hall?
I believe it's confidential, but
If it's a matter of public record, yes.
Is it?
I think this is not on the agenda, Mayor Hayden, and I would
Multiple
encourage you to
people know about it,
move
right?
on.
contact City Hall then and see if what information can be shared.
I sure will.
All right. Anyone else wish to address the council on this issue? Come forward then, please. Identify yourself.
Yeah, my name is Bob Scrisati. I live at 5181 Keller Ridge Drive. Question asked that nonprofits will not buy a house in Clayton is wrong. I have an Oakland nonprofit housing right across the street from where I live. It's a state facility that houses 4 people that are incapable of handling their own lives. So their price was $825,000 they bought that house for. There are some regulations that I talked to the person in Oakland that runs the nonprofit that the state has put on them. One is they not only check the inside of the house, but they make sure the outside landscaping and everything is maintained. So I have a couple of questions. One is, how often does the county check on them? Do they visit every 6 months, every year? What type of education or training does a supervisor have that regulates the parolee? What regulations do they have for that purpose? And I guess the last question would be that as a homeowner and my ability to call in to the city to say, hey, you know what? They're not keeping their landscaping up. They're not doing this. They're in conflict with one of our ordinances. What is the city going to do about that? Are they going to send out police officers? Somebody go out to check? The other thing is, when I bought my house, I had the conditions that we all had when they first built the track up there. And when I came down to talk to several people down in the city hall, they mentioned that, sorry, that's your legal issue. You go sue them when you have the CERs. So I'm really concerned because I'd like to know those 3 things. I mean, nonprofits have money. As soon as the costs for police go up, you're going to find people buying houses. They did it when I was in Walnut Creek at $925,000. They're going to do it here too, as long as they can make money on it. So I don't know what regulations really nonprofits have to go by. It seems to me that there's a lot of nonprofits and they must be making money. So again, you heard what people came up here and talked and shared their concerns. And I don't have a problem if we have to go with an option 1. But I sure would like to know who's the training to control these parolees when they're in that area. The other thing is you have some duplexes and condos that are young people in there. They have children. Think about them. Thank you.
All right. Thank you. Anyone else? Excuse me, there was a woman in the back there. Sorry, she's had her hand out for a while.
Hello, my name is Linda Cruz. I live at 359 Chardonnay Circle. I wasn't prepared to say anything, but I've made a few notes. I moved to Clayton 38 years ago to be to a safe community, to raise my family. I've had a murdered brother. I've had a house break-in and robbed. I'm from San Francisco. And we left the filth and crime of the city to move to Clayton. I have a brother that works with parolees, and he saved one out of hundreds. And I'm totally against parolees coming to Clayton. I want to keep this a nice community like we are. Why would we want to ruin a good place? That's all I say. I did want to ask, I do not understand what it means when it says multifamily, low density, multifamily, medium density. Are those choices that you want to put in the regulations?
Those would be the general plan designations that they would be allowable subject to a use permit, and the rest of the city would be a prohibition.
Okay, I don't understand that, so I'll ask in an email.
Okay, or this map right here behind you shows the locations of where the multifamily designations are. The black circles represent those designations.
And one's right down there on Marsh Creek Road. Well, I just don't think that it belongs here.
Okay. One more?
My name's Steve White. I live in the county in Morgan Territory, but unfortunately I'm going to have to drive through Clayton. And parolees, I'm a retired police officer. And Ms., your comments earlier on about changing the definition of certain housing definitions kind of caught my attention. I guess there were some adjustments that might have been made, Ms. Gentry, that could maybe get us in line with some potential realignment up as far as whether or not we have to have this restrictive parolee alignment or not. And I'm not quite sure what it was, what the term was. So long ago, I can't remember what it was, but I just wanted to bring that up, just make sure that was noted. And other than that, I don't know if anybody knows that Contra Costa County recently also backed out of housing ICE inmates, so we're going to have more of those not being housed in Contra Costa County. So we're going to have more out here. Thanks.
All right. Anyone else? Come forward.
Hello, I'm Dina Stevens. I live on Morningside Drive. I too was unprepared to say anything, but now I am. I live next door to a house that had somebody that was living there with an ankle bracelet. Known drug dealer. Known to the city, known to the police. Drug deals. I live on a single, there's only houses on one side of the street. Drug deals all the time. Call the cops. Nothing. What do we think is going to happen when there's parolees? Because one parolee has multiple friends that are probably not nice people. So what do we do with our police force of 3 at the most on duty? That's a question.
Yes, the deployment of the police department is 3 per shift.
Which is woefully inadequate when you've got one person. You know the saying, tell one friend, they tell 2 friends, and so on and so on. That's how it is with drug dealers, parolees. So I'm against it. Thank you.
Could I ask anyone that did speak this evening and didn't fill out a speaker card to fill one in before they leave this evening so we can capture that for our minutes? We'd appreciate it. So, we do have one more speaker?
I just want to reiterate. I'm Rick Martin, and I live at 93 El Portal Place. I just wanted to reiterate a little bit what he had mentioned, because we moved from Walnut Creek to here 9 years ago. And the reason we moved here was because of the problems in Walnut Creek, especially in the area where we lived, where they took and put care homes into these neighborhoods. And of course, by state law, it says that those are private homes. Now, I don't know how this is kind of termed that same way. I don't know if they're listed as private homes, but I believe you did say that if a parolee, if they have one of these homes, that it's basically a private home. It's not a business. Is that correct?
They would be located in a residential unit, yes.
That's correct. And there could be as many as how many parolees in that house?
It would be essentially 2 per bedroom, which would be based off of what the California Building Code allows for occupancy.
Right, okay. So this is very similar to what the care homes were in the Walnut Creek area. And those homes around in Walnut Creek were expensive homes. People bought those homes because of the income that is generated by the people that live in there. And the problems that we had within our neighborhood was that there was nobody that watched the building codes inside the houses. We even had the city of Walnut Creek there looking in front of a house, and we said, what's wrong with the picture of this house? And nobody said, well, it looks okay. Well, does that wall that's in the middle of the living room window, is that code? Well, no. But nobody checks it. Everybody talks about, oh yes, it'll be okay, and people will watch it. You can get this person, they'll come out, the city will come out, but it doesn't happen. And those houses had to be, I think, 200 feet apart. These have to be 5. But the idea of having these houses and thinking that nobody is going to afford these houses can surprise you. Because depending on how much, 6, 7, I mean, they can cut a house up into a lot of bedrooms and bathrooms that are, single level. They can't, but on these, they could even do it more because at least with the care homes, they had to be single levels because people couldn't walk up and down stairs. But here, they can walk up downstairs. So you could make a lot of bedrooms in a house depending on how many parolees you wanted to put in there. So those are things that bother Bob and I because we've seen it, and we've seen it take the neighborhoods down in Walnut Creek, and that's why we moved to Clayton. So that's another thing, because it is something that can take over. Thank you.
Okay, thank you. One more? Well, we can't.
But we can't hear you back at home because this is being broadcast.
Don't give him the microphone.
Well, okay, she's bringing you a microphone.
Yeah.
Well, but the only thing I have to say here is that we moved to this place with our kids from Antioch because it got so bad there. Our kids are grown now, but we still live here. And if the government's imposing this on us, then I say we ban it, and if we got to fight it, we fight it. That's just all there is to it. If the other 2 cities in California banned and they got through it, then we can too. And that's what I got to say.
Can I talk for a minute? And Stanaway again. And really, banning it is not such a bad plan, because if you look at it, you ban it. Okay, somebody comes and they say, hey, we're going to take you to court and we're going to challenge it. You read their brief, you look at their arguments, and you say, do we have a chance? If you don't have a chance, then revoke the ban. How easy is that? All you have to do, you can ban it for now, and then if something comes up that you really think is going to be costly to the city to defend, then all you have to do is revoke the ban and put in one of your regulations. That's it. Thank you.
Okay. Anyone else? All right, I'm going to go ahead and close off then public comment and bring it up to the council for discussion. Do you? Or anyone else want to kick it off?
I'll start, I guess. So, so as I hear all the concerns, so as I look at the three different options, maybe I'll just run through kind of what my thoughts are on each of them. So, option 2, to do nothing. We have a moratorium that expires on October 3. If we do nothing, parallel housing would be allowed anywhere without any notice, without any permit, without any process. I'll explain why that's absolutely a no-go option for me. I moved into this community in 2005. I have 2 young kids. They're still young kids. They still go to our schools. They still walk our trails. They still bike to their friends and back and forth. Safety is absolutely number 1 on my agenda as well. I'll give you an analogy, which is this particular ordinance does not address sex offenders. However, we do have a couple in our city. One of them happens to live in my street. A couple years after I had purchased my home, one of my neighbors, my other neighbors, came to my door with a copy from the Megan's Law Registry indicating that one of our new neighbors is on the Megan's list. When that happens, there is no notice to any single neighbor. There is no public hearings. There is no process. There's no permit. The only requirement that the state has is that there's a radius requirements relative to schools. That is it. So when that happens to you as a property owner and as a parent, your heart drops at that moment. And that is exactly the type of scenario I could imagine that could happen under the parallel housing. When somebody moves in next door to you, you're going to have questions. Perhaps they're fine. Perhaps the parallel home works just fine. It's a housing type that we probably need in this state just as well as any other housing type. But at that point, if it already has happened, if there was no process, no hearing, no notice, there's not anything that the city can do. I don't think that's the right approach. I would rather regulate it than allow it as a right. Then to go to the next option, which would be to ban it, which would be option number 3. I personally think that would be an invitation for a lawsuit. If we play that type of gamble, I think we're risking city monies, city resources. I don't think either of those are plenty. We're a small city. Our budget is not that large. And more importantly, I think the way in which it would play, I don't think it's as simple as if we get sued, then let's quickly change our ordinances and go to something else. And city attorney can correct me if I'm wrong, but I think what happens is you're in a lawsuit, you're allowing the court to decide what your ordinances should look like. So I'm concerned about risking our monies, risking our resources, and putting us in a place where we're no longer deciding what our land use regulations should be, and we're allowing a court to decide where different types of uses should go. I don't think that's the right approach. I think that's irresponsible fiscally, and I certainly don't want Clayton to be the first one out there out of the gates to test this. If some other city wants to take on that challenge, that's fine, but I don't think Clayton should be the one. So to me, the only option really is to regulate it. There are ways in which regulations can be very permissive, or they can be very restrictive. We could obviously allow parallel housing as principally permitted use anywhere in the city. That would be extremely permissive. We could instead restrict it, as the staff is proposing, subject it to a conditional use permit, limited to certain zoning districts only, and so forth. I do land use for a living. I'm on the other side of the dais all the time, helping people with conditional use permits and whatnot. Conditional use permits are always discretionary. There's no such thing as automatic approval. There are findings that the commission or the council has to make. There are, as we talked earlier, there are notices, there's public testimony, there's a process that goes through before somebody can get a conditional use permit. And I think everybody in the audience can imagine if there was a conditional use permit proposal and you happen to be next door to that proposal, you would have questions, you'd want answers. you'd come probably testify, or at least hear what the proposal is about. So there's a process that goes through. So I think that's kind of where I'm at. I do think that the right option, in my opinion, is to regulate it. And I do like many of the things the staff is proposing in terms of it is fairly restrictive regulation. It is certainly more restrictive than some of the other cities around us have, and I think that's the direction I would go. And I'll leave it at that for now.
Okay. Jim?
There was a reference to the flag and God here recently, and I took exception to that because in my belief, I believe in second chances for people. However, not in this instance. My primary responsibility to represent you is public safety for your family, my family, and all of the residents in Clayton. And I take that responsibility very seriously. And I'm not going to waste or suggest wasting resources to challenge the state, the federal government, or whatever, and their unlimited resources to come after us if we choose to ban it, not regulate it, or do nothing. You may want to risk that. I'm not willing to do that. One thing I want to address also is a lady mentioned about our police department. 3 people per day. Yep, that's correct. About 2 to 3 Fridays ago, I was coming home from dinner, and I came around the corner off of Clerker Pass onto Oakhurst, and there were 10 police cars due to a recent armed robbery at the Togo's restaurant in Concord. Guess who caught the robber? Well, it wasn't the Concord Police Department. It was our eyes and diligent police officers of 2 who were on duty. And they recovered not only the money, but they took in custody that individual, his rifles, his bullets that he had in there. Clayton is becoming an attraction point either to transverse or to come in here because of the affluence that's in this city. And whether you don't realize it or not, that is the case. Because that was not the first time that Officer Richania stopped a felon. Less than 6 months before that, he stopped another individual who was armed to the gills. They are trying to use Clayton as a place to transverse, or they are also looking to your residents and mine, because they figure we have some resources there, and that's where they're going to come. If we do allow parolees, and somebody mentioned that, yep, guess who they're going to invite over to visit them? It's certainly not going to be you or me or the city manager or my fellow council members. Most likely it'll be other. May I finish, please? You had your opportunity to speak, and if you wish to address it at the end of my speech, you can come up here. Now, they will be bringing over not you or me or any of those people that we associate with. They will invite other parolees, which will increase the probability that something negative could happen in this city. I am not willing to risk that possibility. So, where I'm headed here is I believe we ought to take some sort of action to regulate this, and I'm not sure if the 300, 500,000, whatever it should be, that is legally permissible. Right now, I live in Oakhurst. I have to eliminate myself from certain issues to vote on in here because legally I can't, because it's in with my 500 feet of sphere of influence. So why can't it be 500 feet? Why can't it be 1,000 feet? Why can't it be 1,500 feet? So I would support some sort of revamping of this, whatever word we use to characterize these individuals, to expand that, to make it a little more challenging, that ends up protecting you, your family, and mine. Thank you.
Mr. Mayor, he invited a response to his comments. I'd like to take him up on that.
Take him up on what?
You said you would invite a response to your comments, I want to take you up on that.
Well, I hope you and your firm would be coming to our aid and assist us in pro bono basis and assisting us in whatever legal action we have. Do you offer that?
No, but I'll...
No? Because no, you make too damn much money.
Excuse me. Let's keep this down. Let's keep this. Come forward. Wait.
I've already made my point.
We'll let this one individual address.
Mr. Diaz, you just said you don't want to risk the city money. Right. You don't want to risk the city resources. Maybe you need to appreciate that you don't represent this city because you are not representing our values or our needs or our safety. Okay. This is what you're paid to do, not chicken out. You had your point. Don't interrupt me.
I have it.
Your position is to do what the public tells you to do. That is what you do as an elected official. You have heard on repeated occasions that people want a ban. Test the ban. If it doesn't work, pay for the legal challenge. It's not up to you to simply decide on your own volition. It is the representative, as a representative, you are responsive to me, to her, to him, to all of these people as well as all the people outside. You don't get to willy-nilly and rule this by caveat. And as for this position, well, we can't take on the resources of the state. What if the legislature passed an ordinance saying Clayton has to put in nuclear waste dump in the city council? Are you just going to go, we can't fight the state, I guess it's got to go there? It's called manning up, sir.
And I have done it for the last 30 years.
Excuse me.
And I'll be happy to discuss it with you privately outside of here.
I'll debate you any day, any
Excuse me, both of you.
Any day, any time, Mr. Diaz.
Okay.
It's got to be open to the public.
That's enough for now on this. We want to keep this motion focused on the issue before us, and that's the parolee housing ordinance that's being proposed. So, any other, we did have the public comment session open, and I believe everybody spoke. So this is still comment for the city council to discuss. Julie?
Yeah. This actually was brought up by one of the public speakers, and this can be, I think the folks that moved from Walnut Creek mentioned this, it can be a lucrative business for somebody. My understanding, and correct me staff if I'm wrong, but my understanding is there is a subsidy of $1,200 per person that is housed in these homes. So it could be lucrative if you cram enough people into a house. Right now, that can happen automatically without us knowing about it. When this moratorium goes away, that can happen. And we won't know until we get that first phone call. So that's a concern. I want to correct a couple of statements, one at least. There was a comment that we had 4 years of budget reserve. That's absolutely false. We have 1 year of budget reserve. One only. That's not a lot of money. That's only a little over $5 million. That goes nowhere when you're fighting a lawsuit. So, just a couple of corrections.
You need to hire better lawyers. Yeah.
You know, I'm going to make another statement here, and you're not going to like it, but you all had your chance to speak. It is now our chance to speak. I did not interrupt you except to answer your questions. I'm not going to ask you any questions. I'm going to make a statement. And I would appreciate your respect for that. I have talked to a great many people over the last couple of weeks about this issue. I talked about it to my dentist today. These people want regulations. They understand the regulations will protect us. They would rather not have parolee housing in Clayton either. I don't want it. But AB 109 is now state law. The county is implementing it. They are contracting with nonprofit and for-profit agencies who are looking for locations to house these people. Any place that has housing is a target for them. Any place in this county. And as we were alerted 2 years ago, before our temporary moratorium went into place, many of these groups want to avoid any kind of public permitting process so they can fly under the radar in locating their facilities. Currently, our Clayton Municipal Code does not define parolee homes at all. The Clayton Municipal Code allows group homes of 6 or less anywhere in the town without a permit or notice. These include senior care homes, small daycare homes, those kinds of things. Automatically, no notice. We don't even know they exist unless there's a complaint. Without a specific definition in our code, parolee homes would be considered a generic group home. They would be a generic residential use. So we have 3 options. Option 2 up there is to do nothing, leave the code as it is. Parolee homes could be located anywhere in Clayton. We wouldn't even know they're there until we receive a neighbor's complaint or the Clayton PD gets a call for service. We could do number 3, ban them outright and invite a lawsuit. The ACLU has already put the city of Antioch on notice that their regulations were pushing it too far. And they were basically notified that in no uncertain terms they were likely to be sued. I honestly don't believe that's a good use of our resources. Clayton would be easy pickings and big headlines for a group like that. Can't you just see it? As someone said on the Nextdoor site, Clayton is mostly homogenous. Wouldn't that look good to everybody on a newspaper headline? Clayton doesn't want those people in their town. Well, you know what? We don't want criminals in our town.
Wait.
It's my turn to speak. Thank you.
Wait a minute. Let her finish her statement, please.
You
asked
me a question. I'm a member of Nextdoor. I can read every comment anybody puts on there. I don't have to respond to be able to read it. I am not willing to jeopardize the city of Clayton for a lawsuit like that. We can pass this ordinance defining and regulating where these kind of homes can be located. We can establish a very public, transparent process. We can require a use permit, including broad public notice to the entire community in the newspaper and mailed directly to neighbors, and we can establish the circumference from this as we choose. We can require a public hearing and add appropriate conditions to provide for community safety. The residents will have a chance to comment at those hearings. I am sure they will not be anything different than what we're hearing tonight. So I personally would want to know if a parolee home was being proposed in my neighborhood. So would you. Without this ordinance, I won't know, and neither will you. I would want to know it had permits and conditions. You would too. Without this ordinance, we won't have that ability. It's simple. We can control how these homes, which are mandated to be allowed, are noticed, permitted, and conditioned. We can make it simple, do nothing and allow them anywhere, or we can define a very narrow range of options in a very public process. We can put them on a broadly seen radar so everyone in town knows and weighs in. We know they will likely go where there are no regulations. There are still a lot of cities without any regulation for them to go to. Wouldn't you prefer they go somewhere else?
Okay.
I'm done.
Well,
Mayor, she's introduced a whole bunch of new information that we should
She's explaining why she is taking her current position and what it's based on. So that's what it.
Also introduced new information that we should be able to publicly comment on.
You had your opportunity to publicly comment on your concerns, so you can listen. You can listen to our discussion.
Mayor Hayden, I do want to reiterate that the public hearing is closed and that Councilmember Pierce was referring to a letter that was in the staff report that was publicly available.
Okay.
So it's not new information.
All right. I want to address what I think are the concerns that many people have shared on a variety of social media and this evening as well. There's a community-wide interest in prohibiting and certainly limiting parolee housing in Clayton. That's certainly what the ordinance was being proposed to address, because as you heard tonight, without a new ordinance, this current moratorium will expire, and at that time, there are no regulations that would control parolee housing in Clayton. And the people that say they don't want parolee housing in Clayton, their concerns would not be met if we have absolutely no regulations. In fact, we would become then a likely location for people who want to develop those homes. So we're trying to protect Clayton by coming up with the best solution based on what's going to occur when the moratorium expires. So you heard the discussion on the 3 different options available. The first is to take nothing, and I think that exposes us to too many negative impacts that we would have no ability to react to, because by the time we would find out about it, because no notice or permit would be required, it would be too late for us to take action and protect you in those cases. So that attempt I don't think is viable. It doesn't provide the protection I think you're entitled to and that we want to provide to Clayton. The next option is the ban, and I think that also would be subject to challenge, and the suggestion that we put a ban in place and just revoke it if it looks like that would not prevail in court. By that time, whoever is challenging it would be able to go through with their development. So that, again, is not a viable solution to provide long-term protection for Clayton. So the best approach appears to be what many cities in Contra Costa County, and that's our environment. We don't look to a large city in Southern California with deep pockets who implemented something years ago as an example of a current solution to a new problem created by the state of California. That's creating this potential influx of parolees going out into the local community. That's what the state's trying to do to alleviate the overcrowding in the prisons. So, excuse me, you had your opportunity. Excuse me. No, ma'am, you're out of line.
We don't say no. You say 8 people are going to say
Excuse me.
We don't believe it. You're going to.
You had your opportunity, ma'am.
Go to the whole place, including you guys.
You could have. We have been elected to represent the best interest of Clayton. That's what you elected us to do, and that's what we're attempting to do. We're not responding to demands from individuals who aren't reading the entire record and viewing the options with an idea of what's the best solution to protect the majority of citizens here in Clayton, and view it as what would you like us to do to protect the house next to you from being used as a group home for parolees. Today, if we do nothing, that's potentially what could happen. So we're trying to protect you from that danger, and we also view it as potential danger. So that takes us to option 3, and that's put restrictions in place that not only protect Clayton, but become a deterrent for any future group home developer. I call them a developer because they're developing that concept. They would not look to Clayton as a potential site. They'd go elsewhere that doesn't have regulations or that has much easier regulations for them to live with. So we're trying to put regulations in place that require public hearings, so all the neighbors in the community is advised before anything like that is approved. There's a number of requirements that would have to be met, and if they're violated, we can take action. That's another thing that we're unable to do if there's no regulations in place that can be enforced. So in many cases, people feel that regulations are unnecessary without looking at what they permit the city to do and to take action if they're violated. In many cases, and that's what we're attempting to do here, it provides more protection up front and if they're violated. So I agree with what I'm hearing tonight on the council, and that I think regulation would be the best solution to protect Clayton long term. It would be something that could withstand legal challenge and provide protection and deterrent from future development. So I'm also in favor of the regulation option. So,
Mr. Mayor?
Yes?
With that, I would move to have the clerk read ordinance number 483 by title and number only and waive further reading.
Excuse me, Keith. Your city council person to the left or to the right of Ms. Pierce suggested that to look at increasing the restrictions, and you don't seem to have to digest that. Could you comment?
He can make that comment based on the motion that was just made.
I would actually amend my...
You'll hear the motion.
I would actually amend my motion, and I will thank you for reminding me. I would like to expand the notice distance from 300 to 500 feet. And
Those are the buffers.
we already have in there 1,000-foot distance in between prospective locations. So I would suggest we leave that alone. But I have made the motion to introduce have the clerk read ordinance number 483 by title and number only and waive further reading.
We could obviously have multiple motions if somebody else wants to do something else, but I'm happy with that motion, and I'd second that.
All right, it's been moved and seconded that the proposed ordinance to approve the motion. Have the city clerk read the ordinance 483 by title and number only and waive further reading.
May I add a comment?
Yes.
I would like to explore expanding these limits to see what is legally permissible. And I'm not sure if it's 500, 1,000, 2,000, but I would like to explore that, because the action we take tonight doesn't necessarily mean that the ordinance or these regulations will be put in place. Is that correct?
It could be amended at the next meeting.
It could be,
yes.
Thank you.
And if I might just clarify for Councilmember Diaz, we did look at these, this radius very closely. So we expanded it from 300 to 500 feet, but we did not want to expand it further to create a de facto ban. So that is how we settled on the 500 feet.
That was discussed.
And I'm willing to test that. Thank you.
So is the motion going to include that?
We could ask for, how about if we ask for maps of what an expanded radius would do?
Okay, whatever somehow accommodates a consideration for that.
Well, I think what our city attorney has just told us is that by going much beyond the 500 feet, you wind up with
de facto, right, I got that.
having no location
Yeah.
left in the city. And
Right.
if that's the case, it's a de facto ban, and then we get sued. I'm not willing to put us up for that. So we could have a map that says what is 750 feet and what is 1,000 feet, just to illustrate the point. And then we can decide that for sure at the next meeting. But I think we need to get this in place.
So that is the
And I
motion.
will address it when it comes up again for the second reading.
And that, you were seconding that motion then?
To have staff come back with additional information. Is that correct?
Well, what's the actual?
I'm moving to introduce it the way it is now and asking staff to come back and show us the graphic of what a 750-foot and a 1,000-foot ban would look like.
Mr. Mayor, procedurally, the
Yes.
motion on the floor is read by title and number only.
Right.
Yes.
If one of you do not vote in favor of that, the city clerk must then read the entire ordinance.
We would like to have it read.
And so, however, if you don't agree with the ordinance as presently constituted with the amendment for the noticing of a permit then applied for a parolee housing to go from 300 to 500, then you would vote no to not approve the introduction and first reading.
Yeah, but this
And then
first
if
one
that
is
were to
to
go
read it.
forward at your next meeting, we as staff can come back with additional maps that show what a buffer of 750 or what 1,000 looks like, various, some variations. And then if you decide would you prefer that, you could reintroduce the ordinance with those changes for reintroduction. And that would start a first reading once again. But you have time to go ahead and get the information, and still, you don't have to vote for the ordinance at its adoption process.
And we can amend it at the second meeting as well, correct?
That's correct, but then you would be reintroducing it for its first reading.
And we would want to continue the public hearing if that was the desire. Otherwise, we'd have to renotice a public hearing.
Because that would be a substantial change when you're dealing with the buffers.
Okay.
Well, an option then would be just to continue this based on the new information before we make the first reading.
I honestly don't think that it's going to be something that will be acceptable once we see those maps. So
Okay.
I'm happy to look at them, but I believe we're at the right number now.
So we can go ahead with the first reading with
Well,
the
we're in-
introduction.
We're having her read the ordinance by title and number only and waive further reading.
Right. That was seconded, so all in favor of that motion?
Aye.
Anyone?
Just to read it.
Just to read it.
By title number only.
Okay, I'll agree to that.
Okay. Anyone opposed? No.
Ordinance number 483, an ordinance of the City Council of the City of Clayton adopting amendments to Clayton Municipal Code Title 17 zoning in order to restrict and regulate parolee homes in the following general plan designations: multifamily low density, multifamily medium density, and multifamily high density, subject to a conditional use permit.
I would further move to approve ordinance number 483 for introduction to restrict and regulate parolee housing to multifamily general plan designations, subject to a conditional use permit, and expand the notice, change the noticing requirement to 500-foot radius from the proposed locations. And further ask staff to bring back the additional information we just discussed for illustration purposes.
Second.
Okay, it's been moved and seconded then, as Julie has proposed. Captured that? Janet? All right?
Yeah, I'm okay with that, but I definitely want to see if we can expand these limits. That's, okay, that's what I'm agreeing to.
It'll either work or it won't.
All in favor then of the finding the adoption of the ordinance as proposed?
Aye.
Aye.
Aye. Anyone opposed? No? All right, so this will come back then. What is the next step then?
The next step is to bring back the adoption of the ordinance as amended with the public noticing expansion from 300 to 500 feet, bring the additional maps that show what a 750-foot radius might look like or 1,000, and you can decide at that point in time.
And this will
All right.
come back for the meeting on what date?
August 21st, that's your next meeting.
August 21st.
All right. What? Paul?
We'll deal with it later.
Okay.
Well, Ms. Gentry won't be here for August 21st, but you could, then it would be pushed into September.
But staff can still produce the maps for the August 21 hearing, yeah.
And a staff report.
Correct.
Okay. All right.
Okay.
That item is then concluded for this evening.
Can I just ask one question? Where does it come into when somebody decides that these can house 5 people, 6 people, 8 people? Where does that come under this discussion?
That's part of the public hearing process.
Yeah, that's why we want all of these to be publicly noticed and everyone aware of the potential impacts and provide input. Okay. All right, we're moving then on to item 8, which is issue I asked to be placed on the agenda, and that's to discuss some vacant opportunities for Clayton citizens to participate in 3 different regional advisory committees and to discuss how we might request more participation from the public and volunteers for those positions. So, Gary, did you want to address that at all?
Certainly, Mr. Mayor. You asked for this item to come back because we have several positions that the city is entitled to have representation on, and there seems to be some difficulty and some chronic difficulty in getting individuals to apply for those volunteer positions. We indicated in the staff report there's 3 of them that are existing right now. One is the Central Contra Costa Transit Advisory Committee, otherwise known as the 3CTA, and that one deals with the county connection and the buses. The second position to represent Clayton is the Contra Costa Transportation Authority Advisory Committee, Citizens Advisory Committee. That's been vacant since 2013. The prior one on the bus has been vacant since 2011. The bus one prefers individuals interested in public transportation, preferably individual that has used public transportation or is a rider, but it doesn't have to be. The Contra Costa Transportation Authority has representation from every city, including the county, I believe, and we are one of those that does not have, and they're constantly asking us for citizens to go to those meetings. That's the only position that receives any sort of reimbursement, and the reimbursement is only for mileage to and from the meeting. The first one I indicated on the CTA is a volunteer position solely, and you're responsible for getting there and getting back to the meetings, as well as all the costs are incurred. The final one just recently occurred with the resignation from long-term member Joyce Atkinson as the city's representative to the County Library Commission. They're asking once again can we have someone from Clayton that could serve on there. We've indicated in the staff report that there are certain requirements, but most of the requirements for each of those is that you be at least 18 years old and be a resident of the city in which your appointment might come from. So I know the council has had some difficulty in trying to find interested people to do that. Volunteerism is always a difficult matter, particularly when there's no compensation or a stipend that occurs. And these 3 entities do not offer that. So, Mr. Mayor, with that, I'll throw it back to you in terms of you wanted to have some dialogue on it.
Well, I did want to go ahead and address this in one of the upcoming mayor's columns in the paper, just to remind folks that we do have these opportunities. The city does currently post it on our city bulletin boards, and Gary's been good about mentioning this at city council meetings, but we'd like to expand our outreach efforts to try to generate more interest so that we can have Clayton represented on these 3 different committees. So I'd like to, I think, continue mentioning this also at city council meetings, but I request input from my council members here on maybe other ideas on outreach opportunities.
So I think a lot of us talk to people all the time. We've made these. I would suggest we reach out to any of the groups that we're already in who have volunteers who do things. It doesn't seem like advertising it in the newspaper is getting us very far, but hopefully your column will be read and maybe we'll get some takers and some commitment.
Well, we do have volunteers in many different clubs around town, and often those are the people that are active in community activities and interested in our communities, so we certainly can reach out to those groups and let them know of opportunities and encourage their members to consider that.
So I sit on the monthly library our library board meetings because I'm the council rep there. So I have actually mentioned it multiple times as well to see if any of those people might be interested, and I haven't had any takers so far. So
Even from the board of the library.
even from the, exactly. I have one citizen who recently approached me about one of the transportation committees who might be interested, so I'll circle back with them and see if they might still be interested. But yeah, I don't know what else to do either. I mean, other than being as public as we can about and asking people to look into it and consider it.
Well, I think we can reach out to the clubs in town too.
Yeah.
Because those people are active. Good candidates. All right, Jim?
No, but I tried to solicit some people to help, and no one seems to be interested at this time.
All right. We'll take all the help we can get.
Okay. Well,
Don't volunteer any parolees.
I am a parolee. I haven't been approached and asked to be a volunteer. And guess what? I don't require any stipend. I don't require anything. And I've been volunteering on things since I was about 10 years old. So, here I am.
Well, let me suggest then we do have those opportunities on our website, and it explains how you will apply for that. So I encourage you to look at that. Another comment?
Hi, I'm Alex Restall, and I live on Stranahan Circle. Just some thoughts to get volunteers. I'm thinking of where I go on a daily basis and how someone would reach me. As a working parent, I drop my son off at kindercare every morning and pick him up every night. I don't know if you could hand out flyers because there's a lot of traffic that go in and out of local businesses. I also am on Nextdoor a lot. I don't know if you want to consider putting an ad on Nextdoor. Reaching out to some younger members of the community, you could look at moms groups like Mount Diablo Mothers Club. I'm a member of that, and I know there are multiple other groups that have young parents who might be interested in positions like this. So just some thoughts.
Okay, thank you. All right, we will continue with our outreach activities and try to get some more Clayton representatives on these different committees. Next item is council items limited to requests and directives for future meetings. Pursuant to our discussion this evening, I think I would like to put the fountain operation policy as a future item for the council to review the policy.
I would support that too. I wasn't on the council when the policy was last looked at, and I'd at least like to look at it. Yeah. So
sure.
Yeah.
Sounds good.
Any other items this time? All right, I'm going to recess the city council meeting and move to the Oakhurst Geological Hazard Abatement District meeting.
Okay. I'd like to call to an order the Oakhurst Geological Hazard Abatement District meeting for July 17, 2018. Let the record reflect that all board members are present with the exception of board member Shuey, who's absent today. We'll move on to public comment for items that are not on the agenda. I have one comment card, but it is on an agenda item. So if there's any member of the public who would like to address the jihad on any non-agenda items, please approach the podium. Seeing no one, we'll close public comment, and then we'll move on to consent calendar. Do we have a motion there?
I'll move approval.
I'll second.
So it's been moved and seconded. All those in favor?
Aye.
Aye. And opposed? None. So then we'll move on to item 4A, which is public hearing, and it is the hearing to consider the Geological Hazard Abatement District proposed real property tax assessment for fiscal year 2018-2019. General Manager, if you have a report, please.
Madam Chairperson and members of the board, excuse me, on the June 19th meeting, you approved the budget and set tonight as the public hearing for approving the levy. I do have a quick slide show here, or slides for you. The adopted budget has a total budget of $76,470, of which of that is $35,470 in proposed operating costs. The $51,000 remaining is in project expenditures that are planned for this coming year and future years. There is an adjustment that is done annually. It's the Consumer Price Index adjustment. It's done with the San Francisco, Oakland, Hayward All Consumers Index. This year, the adjustment is a 3.22% increase, which amounts to $1,283 and change over last year's assessments. The two projects that we have planned for the project expenditures are to replace two slope inclinometers. The first at Key Lock Way, which is a cost of approximately $35,000. The second is replacing another slope inclinometer at the Pebble Beach area. It is slightly more expensive due to access issues and further being constructed on a little steeper slope. We obviously don't have enough money in this year's budget to do both, so we'll plan to do the Key Lock and put the Pebble Beach on hold until we've garnered additional funds to make that budget whole. That's my report for you. I'll be happy to answer any questions if you have them.
Are there any questions of staff? Seeing none, then we'll open up for public hearing, and I do have one comment card. Joe Beatty.
Mr. Mayor, my comments are really just questions, and I think it's better to direct them. I can't top the rest of the discussion tonight. My issue doesn't go anywhere near those. So I'd like to address them to the city attorney and to the city engineer. They're just basic questions about the jihad and the tax assessment and Prop 218 and how that meets up. So I will pose those under separate cover to the engineer and to the city attorney and just basically ask questions rather than do that here. Is that okay? Thank you.
That would be fine, yeah. And you have the general manager's contact info, so feel free to connect with him. Are there any other public comments? Seeing none, we'll close public comment and bring it back to the board for any discussion and or motion.
I would move approval of the resolution ordering improvements and confirming the jihad assessments for fiscal year 2018-19.
I'll second that.
It's been moved and seconded. All those in favor, please say aye.
Aye.
And any opposed? That's none. So that item does pass. And then I will move on to item number 5, which is action items. There are none. Item number 6 is board items. If there are any requests for future meetings. Seeing none, we will adjourn, and our next Jihad Board of Directors meeting will be scheduled when needed. And we are adjourned on that.
All right, with that, I will reconvene the City Council meeting, and our next item actually goes to closed session. I do see a speaker's card for our closed session, but closed sessions are in fact closed to the public.
Well,
Mayor,
he can speak beforehand.
so we will take
comment
that.
on that.
He's allowed to speak beforehand.
That's what I was going to say. I'm saying he can make a comment, but he can't stay for the closed session itself. So Brian Bedell?
Yes, Mr. Mayor, I just wanted to raise a point of order. The government code section under which the session is being closed does require a prior open and public hearing regarding, I'm not aware of any such hearing having been conducted, so absent that, I would object as a citizen to the session being closed, as it would be in violation of the government code.
Mala?
This is on the agenda to discuss, so this is the matter before the council, which is the 2 properties listed at Oak Street. This is the public portion.
I understand that, but the government code section under which you're closing the session requires a prior open and public hearing for it to be discussed before this can be closed, and if that hasn't happened, you can't close the session by statute. Read the code.
I'm happy to read it. If you give me a second, I'll pull it up and
I'll pull it up for you. I can read it for you. I've got it right here. Government Code Section 54956.8. Notwithstanding any other provision of this chapter, a legislative body of a local agency may hold a closed session with its negotiator prior to the purchase, sale, exchange, or lease of real property by or for the local agency to grant authority to its negotiator regarding the price and terms of payment for the purchase, sale, exchange, or lease. However, prior to the closed session, the legislative body of the local agency shall hold an open and public session in which it identifies its negotiators, the real property or real properties which the negotiations may concern, and the person or persons with whom its negotiators may negotiate.
That is the agenda description that is on the agenda.
That's not...
Prior to going into closed session, what is on the agenda is the description of the property, which I mentioned, 105, 1005, and 1007 Oak Street with the appropriate APNs. It lists the city's negotiators, and then in addition, it lists the negotiating parties who are interested in purchasing the property, and then the terms are price and terms of payment.
With all due respect, counsel, it doesn't require public disclosure. It requires a prior hearing. That is a statutory requirement that you cannot avoid by simply listing the names in the thing. Therefore, as a citizen, I object to the closed session of this hearing going forward and will consider legal action against the city if it does so. And we'll also move to block any negotiations and sale of the property that come out of this closed session. We can do it one of two ways. We can open the session. The government code says it may be closed, doesn't say it has to be, or you can shelve it and put it on another date after it's an open and public hearing has been. The law, I don't write the laws, you're supposed to follow them.
So I was going to read the purpose of the closed session. Would that be sufficient?
Sure, it would. Thank you, Mayor Hayden.
And it's under Government Code 54, 956.8, conference with real property negotiator. And this is item 1, real properties located at 1005 and 1007 Oak Street in Clayton, California. APNs 119-050-034 and 119-050-008 and 119-05008. This is your instructions for the city negotiators, City Manager Gary Napper, and Mr. Edward Del Becario, Managing Director of Transwestern, regarding price and terms of payment. Negotiating parties are Mr. Michael Piez, the Case Group, Investment Real Estate, Lafayette, representing Luis Munoz.
My objection was made on the record, Mr. Mayor, and I reserve my rights to pursue legal action on behalf of myself and the other residents of Clayton should any sale go forward. Like I said, I don't know what this is about. Might be a great thing, but closed session, we don't know.
All right.
Thank you, Mayor Hayden. And to clarify, the government code section that was cited does not require a public hearing. It just required the council in an open and public session, which you just did, to identify the negotiators, the real property, and the persons with whom the negotiations will occur with. So thank you, Mayor Hayden. Thank you.
Gary?
Mayor Hayden, maybe I can try something. First off, in just a little bit in closed session, the City Council in closed session can discuss the item, but the City Council cannot bind itself or the city in closed session. That would then, if the council were to instruct its negotiators to a certain price, a certain payment, that would then have to come back at a subsequent meeting on a public meeting that is noticed to the public.
And open session.
In open session.
Correct.
And the purpose of a closed session is so that you can instruct your negotiators on the price and terms of payment without notifying the other party what you're interested or your caps or your thresholds are, so that you're not negotiating publicly with the other party present. So again, it is limited to price and terms of payment, the closed session, and then any subsequent action to potentially sell the property would have to be done in an open session setting.
And that is the intent of the particular closed session this evening.
Correct.
Yeah.
All right. With that direction then, we will move to closed session.